This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are talking with Professor John Weil about his new book, The Writing and Ratification of the United States Constitution, Practical Virtue in Action. Professor Weil is a political scientist and is Dean of the University Honors College at Middle Tennessee State University. He is the author and editor of numerous books on the United States Constitution, and we're glad to have him. John, glad you're here.
Thank you. Great to be here.
John, let me ask you from the beginning. The subtitle of your book, Practical Virtue in Action. What did you mean by that?
Well, it's actually a paraphrase of a statement that William Patterson made. He actually said practicable, which I think is a bit antiquated. But basically what I'm trying to emphasize is, as we all know, the Constitution is not a perfect document. Nobody ever anticipated that it would be. It was a practical response to some very real problems, and in my judgment, did a remarkably good job at addressing the primary problems that it was designed to address.
I want to ask you, why do they want a written Constitution? What is the efficacy of a written Constitution? Why do they think it's going to solve their political problems in a way superior to unwritten common law tradition that they have as
Sure.
Englishmen?
No, it's a great comment, particularly because, as you mentioned, not only did they not then, but British still don't exactly have a written constitution unless you include, the European conventions as part of the EU. I think part of the reason that the founders so much like written constitutions, I believe part of it goes back to their religious heritage. The country was largely Protestant. Protestants put great emphasis on the efficacy of the written word, Scripture alone. And while that's not completely accurate when it comes to the Constitution, because you certainly have to supplement it with other customs and traditions, I think they thought there was a certain security in having a written document. Of course, they already had a written document with the Articles of Confederation, and I think it would have been difficult once you had one to go back to an unwritten constitution. And of course, at the state level, one of the things that we forget is immediately upon independence, and sometimes before Congress had actually declared it, Congress had told the states to begin rewriting their documents, and many had done so. And in the conflict with Parliament, many of them had relied very heavily on their original charters, as well as on documents like the Magna Carta, no taxation without the representation, and the like.
On the Articles of Confederation, there is, some debate that continues about, were the Articles actually failing? And there are some lonely scholars, I think, that argue that they were not, that there are certain people who are in a hurry. The bargain they thought they were going to get with independence hasn't happened, particularly with respect to commerce. There are also a lot of other problems. Currency is also a problem with state governments printing their currency. So I wanted to get your opinion on that. Were the Articles of Confederation failing, or in any event, did enough people believe that they were, so that maybe that question is of lesser importance? And other precipitating events leading to the Philadelphia Convention?
I think that they were, and I think there was a fair consensus that they were failing. I think there was probably greater consensus among the elites that was happening than there was among others. I think maybe the question that is harder to answer is, was there a way of fixing the Articles other than going to the direction that the Constitutional Convention made? And it's possible that there was. I will say that in part, I think that, while the Virginia plan, which Madison introduced, was most people consider very nationalistic, it was toned down considerably, particularly by the delegates, most notably Sherman and probably Ellsworth in Connecticut, to make it a more, I guess I would say, federal document, to not forget the role of the states. And I think the result has been a pretty good compromise.
Interesting when you bring up a question of legitimacy, maybe, for the Constitutional Convention, given that they are sent by their state legislatures to amend or to revise the Articles of Confederation. Certainly
Yes.
not to do the work they did, although there are some interesting arguments made to justify this kind of wholesale work that they do of putting forward a new constitution, and yet also amending the articles required unanimous consent. Obviously, they don't have that. So the problem of legitimacy, how do the founders sort of situate themselves to get around that sort of rule of law question?
Right. The main answer is the ratifying conventions. I spend a lot more time in the book on the writing than I do on the ratification of the Constitution, but I included that in the title and have a chapter on it because it is important to remember that what emerged from the Constitutional Convention was a proposal. And they did bypass the articles by saying that the new Constitution would go into effect among among 9 states or more that ratified, but no state was compelled to come in. And truthfully, even if 9 states had ratified and you had ended up, for example, without some of the last states, without Massachusetts, without Virginia, without Pennsylvania, I think it's very unlikely that the new government would have gone into effect or certainly not succeeded. So I think in a way almost like Californians today regard the referendum as sort of trumping everything else, the founders put strong emphasis not only on conventions to write, but also on the ratifying conventions. And I think they were a little bit, if you read the Federalist Papers, they're a little bit defensive about the fact that they are bypassing the articles. On the other hand, they had since 1780, they had a good 6 or 7 years of obvious problems, particularly in relation to raising taxes and regulating commerce. And on a number of occasions, they got all the way up to 12 states, and then Rhode Island, and in one case, Virginia approved and then withdrew its approval. And so I think they, partly it was desperation, and sort of what you said, necessity knows no bounds, but still an accountability in the sense that if the states don't agree to this in convention, then the new Constitution will not go into effect.
So interesting to contrast the state ratification conventions, theoretically built on the people, built on the people's consent as a way to legitimate the Constitution. Which, if we look contemporary problems of the European Union and their attempts, and they really can't reach the people. It seems they really don't have that sort of direct connection with the people. They have only a connection with the member governments, which seems to bring forth an illegitimacy problem for the European Union that it can't really solve.
Well, and of course you do have some cases in the European Union where there have been nationwide referenda, and frankly the ratifying convention came as close as they had sort of to our modern referenda as anything.
Thinking we get into the Constitutional Convention, central point of the drama of the convention seems, there are a lot of things in play. It seems to be that theories of representation are huge, and who's going to be represented, who will do the representing, and is it going to take shape around the states being equally represented, or a national representative model. And I found that interesting because the subsequent history is really a sectional crisis over economics. Really over a slave-owning economy versus a modernizing industrial economy seems to be the source of the big splits and so much of our political discord after that. This seems strange. Than the convention, it centers around big states versus small states.
I do think that was a central issue. There have been some who have tried to argue. Martin Diamond was a good example, and a great scholar. But I think ultimately I do not agree with what I believe to be his conclusion, which was that the main fight at the convention was between those who thought we needed a stronger government and those who thought we didn't. I think all of them recognized we needed a stronger government. Some thought it needed to be stronger than the other. I guess the only maybe what I would pick up on in your question is it wasn't it wasn't so much an argument about theories of representation as it was an argument of interest. The larger states did not think that it was fair for them to continue to have a single vote, and the smaller states had no reason really to give it up other than public spiritedness and the hope that it would ultimately help the entire union. There were debates over slavery, and some of them were fairly passionate. And to some degree, those debates, the Three-Fifths Clause, to some degree, ended up giving Southern states greater representation than they would have been entitled to simply on the basis of number of citizens in those states that were voting. But I do think you're right. The large state, small state was the biggest controversy.
Where does that ratio 3/5? Where does that come from?
It was a formula that had apparently been used in the Articles of Confederation. This is one you don't go to ethics textbooks to figure out where they came up with it. It was just somebody came up with it and it stuck, and rather than relitigate it, they sort of accepted it. And I've never been. You can make it sound awful, and it does. I've told students I think it's the worst part of the notion of considering someone 3/5 of a person. On the other hand, it does use that language of personhood, and it may provide it a little bit more of an entering wedge than we realize for those who would later argue on on the basis of humanity and equality.
The 3/5 clause. I mean, I've heard people argue that it comes out of the ratio itself comes out of a labor argument, and that is a slave
that there were 3/5 as productive
as a white male worker, because inherently your slaves had to lie fallow part of the year and weren't productive, and so the 3/5 number would have come out of that. And interesting.
I don't know that.
Yeah, I don't know
did.
if that's true or not, but I've heard that said.
Yeah, I don't know that it did, but there are. Prior to the Three-Fifths Clause, there were discussions of representation of population and wealth, and that goes to the darker side of the Three-Fifths Clause. I like to somewhat optimistically say it's 3/5 of a person, but using that argument, it's sort of, well, these are a species of property, and the property in slaves is not worth as much as that in someone who's free.
Interesting. Is there anything to be made that James Wilson, advocate of popular sovereignty, some would say he's a theorist of natural law, very much one of the more, shall we say, progressive founding thinkers. He's the one that introduces the Three-Fifths Clause right after a debate about tax and property as the basis of representation. Is he trying to do something there?
I mean, all of them made compromises. And I don't. It's awful to say after writing a book that I don't remember that specific debate, but I don't right off the top.
I don't know. I've always wondered that, because James Wilson was from Pennsylvania. He's not a Southerner. You would kind of think that a Southerner would have introduced it, but I think it's Wilson and a man from New England, Rufus King.
Well, and I mean I do know that Oliver Ellsworth from Connecticut, as well as Sherman. Sherman was clearly anti-slavery, and yet there's a case or two at the convention where he basically says, as much as I dislike the institution, I don't know why we're discussing that here. That's not why we assembled.
Yeah.
And so sometimes, what's fascinating about the Constitutional Convention is we have a pretty good record. We don't have a recording, but we had one very good anamnesis, if you will, or recorder there in James Madison, and we had an official report of the votes, and we had others who were taking notes. But what we don't always know is what happened behind the scenes, and every now and then you'll just see a glimpse of this in the notes. After the Great Compromise was adopted on the issue of representation, Madison notes in his records that members of the large states got together and sort of discussed what they could do. And you sort of get the feeling that, they weren't happy with it, but maybe like the fiscal cliff today, maybe both sides sort of put a clothespin on their nose and say, well, we didn't want higher taxes and we don't want to cut entitlements, but maybe we both have to give a little bit on this.
the Virginia plan, which is introduced early in the convention by Edmund Randolph of Virginia, yet James Madison is seen as the theorist behind it. This is essentially a nationalist plan, giving wide powers to the federal government. Seems to give a lot of short shrift to the states. And I've often wondered, was this a failure of prudence in Madison's regard, seeming to ignore the historic role of the states, and also that they start as colonies, and this is really where self-governance begins in America, and yet there's this huge switch to national power in a lot of ways in the Virginia plan, and seems to lead to a snapback with the New Jersey plan. And as you quote in your book, there's a famous line from John Dickinson to Madison during the convention to the effect that you've gone too far. I'm interested to know your thoughts on that.
I think that's absolutely right, and one of the reasons I tend to trust Madison's records pretty well is this is not at all flattering to him, and yet he includes it in his notes. I think one of the things to remember is that Madison's experience, we think of Madison as someone who had been in the Continental Congress, and he had 3 years, and I think actually at the time of the Constitutional Convention, he had been reelected and was technically serving, as was a number of the other delegates serving in Congress at the time. But Madison had far more bitter experiences at the state level than he had at the national level. And one of them was fighting back Patrick Henry, who was trying to get the religious assessment, which Madison, thought violated, principles of separation. And if you read the vices of the political system that he wrote, preparing for the convention, he's almost angrier at the states, if you will, than he is concerned with the weaknesses of the national government. And I do think, and I think Madison himself, 10 or 20 years later probably would tell you, although I can't prove this, but might have thought, it's a good thing Sherman and a couple of the others modified what I was going to do here, because we may not want all this power to be centralized, particularly if it means Federalists, as in Hamiltonians, are in control of the government as opposed to Democratic Republicans.
But that's always an interesting aspect of Madison, that he seems to view, with some justification, that the states are a tremendous threat to republicanism. Given,
he does.
A source of things. Another issue at play is creditors being basically stripped of any rights they have in a lot of states.
Particularly in Rhode Island.
Yeah. By essentially Democratic government and the legislatures, and this concerns them. And so this kind of raises the interesting question that it's actually one needs the national government to in effect protect liberty for the new nation.
Right. And one thing to remember is Gordon Wood is the creation of the American Republic goes in sort of the lessons that were learned in the Confederal period, and again, as many of those lessons were learned at the state level as they were at the national, and many of these had close to legislative sovereignty. When Jefferson was governor of Virginia, he was serving for a 1-year term, and when the British came to take over the capital, he was almost captured, and he got a lot of criticism. But part of it was governors just really didn't have that much power at the time. There was not much of an independent judiciary in many of the states. And one of the things that happened as a result of the Constitution is that many of the constitutions, including Pennsylvania and Georgia and probably many other states, were actually reformed after the Constitution was written to be more consistent with separation of powers and checks and balances and some of the mechanisms that we consider to be effective at the national level.
Question about frequently the founding generation is criticized as elitist, as anti-democratic, as wanting to shield the government from the people because a fear of mob rule, or fear. There's also the progressive charge of they're trying to protect property, and that's really what's going on here. I'll ask you, it seems one way to evaluate this question is separation of powers. And, thinking of James Madison's statement, and I forget the Federalist paper that one Socrates in a group could easily
Yes.
turn into a mob of 30 Socrateses, and so I think the separation of powers is important because obviously we're not a government, we're not a country with rank privileges or any sort of nobility or title, but yet there's the real desire for a bicameral legislature and for them to be different and to have a different sort of composition and makeup and perform a different function. But with separation of powers, does this give us sort of a way to think about or answer that charge of they're anti-democrats? What actually not really. They want a government built on the consent of the governed, but also a government that moves with wisdom and a certain amount of reflection.
That's certainly what they were aiming for, and in fairness to them, when we think about most bicameral legislatures prior to that time, the second house was weighted largely on the basis of either an aristocratic elite or on the basis of wealth, and there were a lot of discussions at the convention as to whether how much property a person in the Senate should have to have, and that sort of thing. And if they had really wanted to go on the elitist side, they could have required those kind of things, which they did not. I always like to quote Mr. Jefferson, who referred, and Adams said something very similar, that they were aiming for an aristocracy, but it was an aristocracy of virtue and talent. And sometimes you might question the virtue because it turns out elites aren't always any more virtuous than those below them. But the concept, I think, is a good one, that we were going to be not a classless society, but we were going to be a society where, regardless of the class to which people were born, they would at least have the opportunity, through popular approval and through their own hard work to ascend.
On the question of separation of powers, I wanted to talk about executive power and presidential power because this always fascinates me. They're really, I think New York may be the only model of kind of a unified executive strong power that they can appeal to. And yet, they do erect a fairly powerful executive. On the executive, what are they rejecting and what are they affirming as they build that part of the Constitution?
Well, they have sort of two models. That one very bad in their judgment and one very good. And the bad model, of course, is George III. And the irony is, George III isn't quite the absolute monarch that he's portrayed, because he's in a system where Parliament is supposed to be sovereign. But he's sort of their, the negative, and then the positive, obviously, is George Washington. And one of the fascinating things about the convention is, almost everybody there is convinced that whatever this presidency is going to be, particularly when they decide that it's going to be a singular, presidency, which the Virginia plan favored rather than the plural executive of the New Jersey plan, is almost everybody recognizes it's going to be George Washington. And there are a couple times, one where Benjamin Franklin, if I remember, has to sort of intervene and say, you guys aren't talking here, but we really need to talk this out, with the implicit understanding, even if George is in the room here, we need to decide, just because powers are good for him doesn't mean that it necessarily will be good for his successor.
On executive power, I mean, how the power they construct versus the presidential power that is exercised now. I mean, talk about some of the differences. It seems in the Federalist Papers we have this notion of the president has an auxiliary precaution, largely ensuring that what comes up to the legislature is in accord with the Constitution, is in accord with basic principles of liberty and those sorts of things. And yet, now we look at our president. He's got to be a national leader. He has to really embody the country and his rule. And this also seems to be there's kind of this notion he is our one representative, and we kind of look to him and not to Congress for so much of the impetus in government and energy in government. Have we lost something important, or is this a beneficial change that we've made?
I'm going to say certainly in the Federalists you see almost all the references to energy in government, particularly Hamilton's center on the institution of the presidency. It's almost like the presidency is a spark plug in I don't know if it's fair to say that Congress is a Greek chorus, because it's certainly more than that. But they did not limit the presidential veto simply to constitutional matters. I mean, I think there may have been an understanding that it would be primarily used in that direction, but certainly in recent times, presidents have vetoed things not simply because they thought they were unconstitutional, but because they thought they were unwise. Part of what may have happened is, in Madison's original plan, he called for something known as a council of revision, and he also called for a congressional veto of state legislation. And although he did not get either of those mechanisms, we did end up with a constitution that is, fairly broad powers but not absolute powers of the presidential veto. And we also ended up with a system which I think anticipated and certainly is compatible with the exercise of judicial review. Judges deciding that laws are unconstitutional. So I think we did end up with a stronger president maybe than was anticipated, but we also ended up with, I think, a stronger judiciary probably than many people anticipated going in. And certainly our Congress is as strong just about as any in the world.
I want to ask you about Oliver Ellsworth's famous statement about the government being partly national and partly Federalist. This seems to be something incredibly new in political philosophy and the practice of government. How are they trying to what were they trying to reconcile? Can we judge this a success? I mean, obviously, we look at the Civil War and think, the Constitution maybe even failed to do this balancing act. But partly national, partly Federalist. What does that mean exactly?
Well, I mean, the frustrating thing here is, we today know what a federal government is, and we sort of think that the framers did, but they effectively invented it. What they call at the time a federal government is what we call a confederal government, where the national government is almost completely dependent on the states, and yet they were trying to avoid the unitary system which they had seen in Great Britain. And sort of the irony of Ellsworth is, Ellsworth is one who's pushing the Connecticut Compromise, and he would have been with Dickinson and telling Madison that you've pushed things too far. But then when you get to, I think it's Federalist 43, Madison is picking up on the very terms that he had sort of opposed during the convention and said, this new government is in fact partly national, partly federal, and by federal he means partly confederal. And so we end up with what I think Patrick Henry referred to as either it was a hydra in government or he referred to it as some kind of amphibian. What kind of beast is this? It's not one like we've ever seen before. And you're right, it didn't completely work. And every time people say, well, the Civil War solved things, and you think that's true, you look at the news and somebody's talking about, well, should we think about secession again, or what about nullification, or some of these theories that seem long dead continue to arise.
When we look at the Constitution that emerged from the Convention of 1787, the Anti-Federalists emerge and are powerful, and they're powerful in North Carolina and Virginia, Pennsylvania, Massachusetts, New York, and all of these state ratifying conventions. They really lead to a very close vote. I think North Carolina were the last states to pass the Constitution.
I think it's Rhode Island, although but both of them end up. They don't actually join the original 11 until they make sure things are to their liking.
And there's this. It's interesting when you read the state ratifying debates. There's kind of this, the conditional language at the end about amendments. I mean, nobody conditionally ratifies. That would be. I mean, some people have claimed that, but that would be rather absurd. There are these conditional amendments that they attach at the end, if I remember correctly.
Right. Madison rejected. When he was asked about it, he clearly said, you either got to go all or nothing. He also indicated, eventually that he was willing to work for a Bill of Rights if the Constitution were adopted.
And I think he specifically stated that in a letter to Alexander Hamilton.
Yes.
The New York Convention, which was highly contentious, and if memory serves, that's where the Federalist Papers. I mean, it's when it's being debated in New York that those start to emerge. But I want to ask you about the Anti-Federalists. What unites them, and are they still relevant? Should we still read them? And do they contribute something to the Constitution? through the state ratification process.
Absolutely. And if I can go back just a minute, I think what you'll find is the solution that was adopted in the state ratifying conventions was sort of the recommendatory amendments, and I think they largely come out of the debates in Massachusetts. And it's like, no, you can't condition your approval, but sure, if you want to put some proposals forward that we'll look at them. I actually have a fair amount of regard for the Anti-Federalists. I think, like people today, they were trying to come up with a balance between liberty and authority. You're introducing, or the Constitution was introducing, a significantly stronger national government. There was reason to believe under British rule that too strong a government could threaten liberties, and I think much of what you see in terms of separation of powers and bicameralism and whatever, these were sort of auxiliary mechanisms that were put in place to say we can both have a government that has sufficient energy to control commerce and raise taxes and defend the nation without threatening individual liberties. And the Anti-Federalists were the ones who, and this goes back to one of your initial questions, why do we need a written constitution? None other than James Madison on occasion refers to it as a parchment barrier, meaning, not something particularly efficacious, and yet Jefferson and others ultimately seem to persuade him that putting things in writing can't do much harm, and it might do some good. And I think there are some occasions in American history where, having scripture-like language that one can go to is a lot more authoritative than just simply trying to appeal to, traditions or customs and usages and historical practice.
Interesting, the Anti-Federalists. Now, if you go down the line, you could see their alarm. Representation. So there's a huge question about size. One of the most important Federalist Papers,
yes.
Federalist 10, and their argument is a healthy natural polity can only be a certain size, and this will dramatically go beyond that scope, and will be dangerous, and will result in inherently a certain amount of elitism and oppression from that result. There's the question of executive power. Obviously, this is something fairly new, I think, in American experience, as we've discussed. Judicial authority, one of the most famous Anti-Federalist papers on the question of judicial review. If I remember correctly, I think it's Brutus. Then the tax power, they can directly tax persons and reach to you directly. And then also military power, the kind of embryonic thread of military power that's there in the Constitution they also regard. So they do seem to have, just looking at the Constitution, I think anyone would have to be somewhat circumspect, particularly if you weren't at the convention, or if you were there and you kind of you left, or you just decided not to approve. I think only 3 didn't, but they do have that going for them, this sheer size and change that's been drafted.
No, I think that's right, and I think almost all of these issues are issues that recur.
Yeah.
I don't know too many people who want to split the United States into 2 or 3 countries, but there are certainly, many of the arguments that we have, from everything from health care to highways, has to do with which entity of government is best able to do things. Executive power, judicial power, taxation, all of these remain vital issues, and sometimes you can overread, well, this is the Federalist position and this is the Anti-Federalist position, but healthy debate has always been part of the national experience.
Well, look at
sometimes unhealthy.
Yeah. Well, I think also there seems to be the question of the Anti-Federalists. They're the ones. This is a debate as well. They're the most significant part of the founding, in terms of they want to make virtue a part of government, a part of the constitutional order, and this seems to be largely rejected. Not entirely, but largely rejected by Publius, and the government is going to be built on interest and motives and ambition of those in their departments, those in the legislature protecting their prerogatives and their integrity. And some of this will all balance and check out. And the government, that'll be the best way to prevent runaway government. So there's kind of the famous line of, this is low ground, but it's solid ground for limiting government. And the Anti-Federalists, write about virtue, and they write about this being something you can't dispense with.
Right. The one area, the one more proactive response is perhaps the Madisonian view that you will filtrate or you will refine representation by having the larger area. That you're less likely to get the party hack if he has a much wider constituency and there's not a single faction behind him. But I think you are right. Madison says elsewhere, if we're not building a government by angels over angels, it's men over men, and we are going to have to rely largely on their conflicting self-interest.
Just to switch fields here, you write in your book a lot about kind of the coming and going at the convention. Delegates arriving late, leaving early, or state, part of a state delegation going home, the other part remaining, which I think was fairly meaningless, right? Or could be, because you had to have a majority of your state delegation to vote, or I forget the rules.
Right. New York, when their two anti-federalists go home, Hamilton can make speeches, but he can no longer cast a vote. And he actually, when they sign the Constitution, you do not really have, well, of course, you don't have anything from Rhode Island because they don't show up. And Hamilton is actually signing on his own. He's not actually signing on behalf of New York because there's not a majority there to do it.
And you document Hamilton's famous speech, 5-hour speech,
Yes.
Elected lifetime president and senators, although I guess there's some debate, was he... it seems to me if you talk for 5 hours, you're serious about what you're saying. But some
one would hope so.
Some have said he is trying to position or to make the Virginia plan look less radical in comparison to the New Jersey plan by his own radical plan. But is there anyone who kind of sketches for us, who's at the convention, who sketches for us these characters and who they are and what they were and what they were trying to do?
Thank you. Wonderful. There's a gentleman by the name of William Pierce from Georgia, who was one of 4 Georgia delegates who attended. He only attended for about a month, and he was a member of Congress. So it appears as though he left the convention for the high and noble motive of engaging in a duel with a business partner, although another interpretation is that he went back to New York to serve in Congress. But in any event, he did character sketches of 53 of the 55 delegates, and I am now actually working on a book on his character sketches, which were published in Georgia newspapers in 1828, and every scholar of the Constitution or the convention knows about these, and to my knowledge, no one has seriously analyzed what he's done. And the beauty of Pierce is, more than any other delegate there, he seems to have an ear for how the delegates said what they did, and so he goes into great length in their oratorical abilities. He had studied at William and Mary and seems to have picked up a bit of a classical education, and it's just a really sort of fascinating, way of looking at the delegates that sometimes we forget that they're human. We think of they're a set of self-interest, or they're representing a large state or a small state or northern state or a southern state, and he gets some of the personalities in there as well.
Does Pierce give us his thoughts or judgment as to who is the most effective speaker, who seemed to be
He
most
does,
in command?
absolutely. Absolutely.
I'm curious.
He really likes Rufus King. He actually is very favorable toward Madison, who doesn't typically get great marks for his speaking ability. He gets great marks for, sort of his logic and his presentation. There are other delegates where he'll say something to the effect that they're great speakers, but you can't trust them. Gouverneur Morris is one that sort of fits in that category for him. And probably, he's not only reflecting his own personal experience, but you pick this up from other delegates as well, that there's a certain inconstancy in some of the delegates that don't quite make them as trustworthy as others.
Let me ask you, and we'll switch fields again. Thinking about certain clauses of the Constitution that have really figured mightily in the expansion of government power. So one is the Commerce Clause, obviously the 14th Amendment, but we won't talk about that. And then we also got the Necessary and Proper Clause, are two. And does the convention, the record, do we get a sense of what they had intended from those clauses? The Commerce Clause, there's obviously the concern about we want a national commercial market.
Right.
But necessary and proper. What can we learn from
There's
the
almost nothing.
it's
just I think it's hardly mentioned. It comes out. It sort of gains significance during the Federalist Anti-Federalist debates, and it's like the Anti-Federalists are far more wary of it than the Federalists are. And the Federalists are basically saying it doesn't mean much, and then then you get to the first Congress, and the bank is proposed, and all of a sudden the necessary and proper clause is elevated to a major portion of the Constitution. So it is fascinating. There's another provision, something on direct taxes, which later was used by the Supreme Court to strike down the income tax. And the discussion is all of something like delegates gets up and says, I don't think we've defined what this tax means. And there's no response, and they go ahead and vote it in. And then 100 years later, it's like, well, what is a direct tax? Well, we really can't tell from the records.
It's interesting with the Commerce Clause. I mean, you mentioned James Madison's essay, which not commented on frequently, it seems, but extremely important, is the vices of the political system. And
yes.
That for me has always been a basic way to think about the Commerce Clause. And all of the sorts of the challenges states are throwing up to commerce, and the way imports are among the states are being taxed, and there's just this concern overall that the country isn't functioning even at the level of exchanging goods across state lines. That seems to be what they're getting at. Of course, the meaning of the Commerce Clause changes with the New Deal,
right,
and becomes a mechanism or a way to
right.
Seems to me block
well,
commerce,
there were two analogies that were used, and one was, I think it was New Jersey was a cask with a tap at both ends, because I think it was both Pennsylvania and New York were taxing the goods that were coming to and from New Jersey, and the other was North Carolina, which was supposed to be have its limbs lopped off both by Virginia and South Carolina because of the taxing there. Now, and part of it is, some of the states were benefiting, and one of the reasons that sometimes New Yorkers, the two delegates from New York left, was they had a pretty good tax situation under the Articles of Confederation, because they were able to make these taxes and nobody could stop.
So let me, as the convention moves to a close, they've obviously solved a lot of problems. They've solved the representation problem. Obviously, we all know about the Connecticut Compromise. We've talked about a lot of the huge changes they've implemented with regards to presidential power and judicial power. What's the drama that they have to face as they leave Philadelphia and prepare for the state ratification conventions, and how does that process end up?
Well, part of it, of course, is, we in an age where we're so used to seeing 24-hour news, the great miracle almost of the convention is that they really did keep things, they kept a lid on things. There may be two or three minor examples of a delegate writing something in a letter that they weren't supposed to, but they were able to come to all these compromises without involving the mob, without having people marching outside demanding this or that. And I think, in retrospect, I think they were probably more concerned than they needed to be about unanimity, but it was like, in part because they had exceeded their mandate. This was such a different beast than most people expected from a mere revision of the Articles. They wanted to get as many people on board as they could, and so Benjamin Franklin gets up, and I probably Wilson read a speech for him because he was unable many times to deliver them himself. But he gave this very, very wise sort of speech on, when you get 55 people together, you not only have the benefit of their wisdom, but you also have their self-interest and their passions and their misunderstandings and whatever. And, this is the best document we can come up with. And I think that's, pretty much my attitude toward the Constitution is, I recognize it didn't enfranchise women. It didn't free the slaves. It didn't give the vote to 18-year-olds. It didn't, solve America's problems with Native Americans. It really wasn't called to do any of those things. It was called to address an immediate problem in government. And, I think it did a remarkably good job of doing that. And not only did it do that, but it left us with a mechanism that, I've written a lot about. We have an amending mechanism that as we are more enlightened and as our interests shift, we can, make changes that will make the constitutional polity much more inclusive than it used to be.
Or we can, well, never mind. I won't say that. Okay.
Well, we can also regress, and I think one of the things that bothers me about so many critics of the Constitution is that we have this sort of self-satisfied smirk that we are necessarily more progressive in all ways than the framers were, and I say give them a break. They were pretty wise people.
No, I agree. I agree.
Well, and I didn't think that you didn't. I'm sort of going after a straw man, but there are real men out there who are constantly criticizing the Constitution, and I understand there are parts that need criticizing, but come up with something better. And there's a mechanism when you do to try to persuade others that you do have a better mechanism.
Professor Weil, thank you for being with us today and talking about your book.
It's been a delight.
The Writing and Ratification of the United States Constitution. Thank you so much.
Thank you.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.